Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. And today I'm looking at a book from Sweet Maxwell and the Thomson Reuters group. It's part of their insolvency library of titles, and this book is a very important one. Some of the writers will be known to you. It's now titled Lightman and Moss on the Law of Administrators and Receivers of Companies. It's now in a 6th edition, been written by the following people. The first, obviously, name will be known to very many people. That's Sir Gavin Lightman. Then you've got Gabriel Moss, Hamish Anderson, Ian F. Fletcher and Sir Richard Snowden, all of whom have put in a tremendous amount of work to give us this new edition. Very grateful to them for doing so, because this is where the law can be found. Now, Elizabeth and I have discussed the book in some detail, and we've given the title of our book review the following: Illuminating Obscurity, the new edition of Lightman and Moss from Sweet Maxwell. As I say, it's now the 6th edition. Let's have a look at the book first of all. There's a red cover. It's a heavy book, actually, and it's a hardback. There it is. There is the spine, a lot of information there for you. You can see that probably. Nothing on the back. There we go. Now, we start at the back. The book runs to quite a substantial number of pages, running to 980 pages in total. Very much as part of the house style of Sweet Maxwell, you have paragraph numbering for the index, and that's the back of the index there. Detailed index, you've got a lot of information in the index itself, and we'll go to the front of the index there. There it is, and it tells you it has the words legal taxonomy, and explains how the index operates and how Sweet Maxwell have a particular structure for keywords. So if you're looking for things, you should be able to find things pretty quickly. I've always found it pretty easy to use once you get into the swing of it. There's the reference, the paragraph numbering there, so you can find things referenced. Now, of course, there are some detailed footnotes all the way through. You can see some of them are quite detailed, specifically about the case law itself in many instances, and of course the legislation. There's the front page. You can see it's a heavy book, as I say, this one. It's got a lot of information. You see all the names of the people involved. The first edition was 1986, and this current 6th edition is 2017, and I'm recording this at the beginning of 2018. You can see the contributors. It's an edited book by the main names that I've given you, but you can see there are a lot of people who contributed to this particular work. There are 32 chapters in total, and there's a dedication which I'm going to show you there, and I'll just leave you to read that. These dedications are important. There are a lot of people involved in producing books. We do not review books that we don't like. We only review the books we believe to be important contributions to what we're doing, and the ones that take our interest as well, of course. There is the actual preface to the 6th edition, which sets out what has happened. That's by the authors, you can see. It's only just over a page. Then there's the stop press, which I'm going to talk about in a few minutes, what's called the Waterfall 1 Supreme Court decision. And I'll talk about that in a minute. And then, of course, there are references to the Waterfall 2 proceedings and the decisions in particular of David Richards, J, as he then was, Mr. Justice Richards, as David Richards, as he then was. Then you've got the table of contents, the 32 chapters. Then you've got the table of cases, never without case law, of course, and there are a lot of cases, runs to a substantial number of pages for the case law. And then after that, table of statutes, and then, of course, not to be done after that again, a lot of statutes. Table of statutory instruments. I always go through these so that you know where to find them. If you've never seen this book before, I think it's useful for newer people too. Table of European Union legislation. I know we're leaving with Brexit. Don't worry about it. The fact is, this information is going to be with us for a long time. This is the European EU treaties, secondary legislation. It's important. It's going to be, whatever these Brexiteers think, it's going to still be around for a long time. And we'll see where we go. Table of international treaties and conventions. There we go. That will be with us a long time. They'll probably change. You never know. Abbreviations. Plenty of them. Lots and lots of abbreviations. There we go. And then we get into the book itself. Chapter 1, Introduction. You see how it's structured. House rules again. House style. Paragraph numbering. And then there's a little bit of footnoting at the bottom. Then it runs through all the way. That's the history of it right at the beginning. And then running through to where we are today. You've got a lot of methods of appointment of an administrator by the court and so forth. You see, everything that you need to know is there. And as I say, this is an authoritative statement as to where we are, and I'm very grateful that we've now got a new edition of it, because there have been changes and there will be a lot more to happen. So what do we basically consider this book to be in terms of what it offers us? Well, this must be admitted that most areas of law are complicated, but the legal framework governing administration and receivership is more complicated still. How fortunate then that Sweet and Maxwell have brought out a new edition, which is the 6th edition since 1986, of which is what is a heavyweight but highly readable and indispensable tome, which now regains its original title, which is here, quote, Lightman and Moss on the Law of Administrators and Receivers of Companies. I know there's lots of words there, have a lot of important meaning, administrators and receivers. People who are involved in this area of law will obviously have a reasonably good understanding of it, but this is where you find the detail which you may well need depending on what sort of practice you have and what type of problem you're getting as counsel in a particular case. I've certainly had a number of the more interesting ones which are off the standard procedural line, if you like, so it's useful to know of the existence of these titles. Now, its distinguished editorial team has obviously aimed to lift, if possible, the cloud of obscurity which has customarily enveloped this body of law, with a view to simplifying its technical and frankly confusing aspects. And I say that guardedly because I've been involved in this area for some time, and I'm frankly even now concerned at how technical, how complicated everything is. And we really should be in an era with higher education and knowledge bounds which are much greater now in terms of the understanding by ordinary members of the public of what goes on, public legal education and so forth. You would think we would be having a more simplified system, but it's getting worse, and there will be the day when it comes to a halt and we have to start thinking again, because we cannot go on continually just making it more and more complex, because frankly even the experts will turn around and say, well, I just don't know. I can't possibly have a full understanding of some areas of the law, so it makes ignorance of the law as no excuse a bit redundant. But there we are. Now, as most will conclude, there's nothing quite like financial services and the laws which govern it to demonstrate just how complex generally a developed society can become, and there's little doubt that practitioners and others involved in company law, or corporate law, whatever you want to call it, will give this brand new edition of Lightman and Moss a brass band welcome, and that's exactly what it should have. This book, say the authors, deals with the law concerning administrators, receivers, and administrative receivers of companies. Receivership, in its various forms they add, has, quote, a much lengthier pedigree, going back centuries, and it was only when the Insolvency Act of 1986 came into force, that the administration procedure for companies first became available under English law. And of course that effectively is the codification. Now, since the 5th edition of the volume in 2011, English insolvency law has undergone significant change, which makes the publication of the new 6th edition all the more timely. And examples are given which the authors cite, with the replacement of the Insolvency Rules 1986 by the Insolvency England and Wales Rules 2016. Now, of course, I go back rather a long way, and I remember the 1986 rules fairly well. And I've been critical of them, and I'll be critical of the current rules because they're still very complicated, but at least we've got something. Of course, it's necessitated substantial changes in the commentary as a result of the 2016 rules. And while the focus of the book is on administration, receivership obviously merits considerable attention, especially when it becomes necessary to meet the needs of secured creditors. But the important thing to remember is the pivotal point of interest in this book is the stop press, because I've mentioned this as the theme running through. It's right at the front of the book, and it's the stop press section that you need to read, because it concerns the decision of the Supreme Court in what we now know as the case of Waterfall 1, which came too late for inclusion in the main text. That's why they put a stop press in. They knew it was coming, but we didn't want to delay it too long. And nonetheless imposes significant impact, of course, on the book's relevant chapters. Now, the Waterfall 1 Supreme Court decision arose out of the administration of Lehman Brothers International Europe, that's LBIE, shortened, Lehman, which, as you'll be interested to note from the detailed stop press section, determined a number of important issues and caused chaos for a lot of people. It was revealed, among other things, that even after having sufficient assets to repay provable claims in full, there was an estimated surplus of around £8 million for distribution to creditors in respect of a variety of other claims. And, of course, Lehman has got a very dubious historical pedigree now in modern law because of what happened, and we are going to see something similar happening in the future. We're not even going to talk about that, but this is being recorded towards the end of January 2018. I'm sure you all know what I'm talking about. There is, of course, a brief summary of what we're saying, but it's interesting to note the comment that, quote, "It is uncommon for an insolvent company to have sufficient monies to pay provable debts in full." That's always been the problem. So you have this structure of secured and unsecured debts by precedent, if you like. Many people don't like it, but that's the way it is. Now, interestingly, references to Waterfall 2 proceedings are also included in the text. So you will need to keep your eye open, bearing in mind this has been published in 2017, and we're now moving towards 2018, and we're going to start getting a lot more information. Now, within the 1,000-odd pages almost, bearing in mind you've got a very large amount of case law at the beginning, so it's about 1,000 pages long, and the 32 chapters. The title provides detailed and extensively footnoted coverage of every aspect of what is complex law in this area, from, for example, taxation issues and the appointment of administrators and receivers, to conflict of laws and the UN Citral model law. And research resources abound, including almost 130 pages containing tables of cases and other relevant legislation. Let me conclude by saying this, that definitely this is an authoritative work, as to be expected, of great reference, constantly relied upon by practitioners, and we are indebted to the people who've actually come together to produce this work. Indeed, anyone financially involved in a company, accountants, company secretaries and so forth, in our view will almost certainly regard this volume as an indispensable addition to their professional library. And as I've said before, it's amazing how often one may need to refer to some of these books. The various library services which Sweet and Maxwell give are really helpful from our point of view as practitioners, because it makes our lives easier. I think it also makes our lives easier for those judging as well, because you are today dealing with really complex issues sometimes. More devious behaviour by twisters is something that we also have to put up with, unfortunately. The publication date is cited as at 2017. As I've said, I'm recording this at the beginning of 2018. Let's have a look at the book finally again. It's a heavy book, as I say. There it is. Nice red cover. And there's the spine. Just opening it up in the middle. We're looking here about employees, transfer of the undertaking. There we go. You've got a lot of information there. You've got a huge amount of detail. You can see the structuring, paragraph numbering, and a lot of footnoting. A lot of case law and a lot of detail. We're moving on. This is transfer of the undertaking, running through there. And then we go to pensions, for instance, another area. Dedicated to bore the pants off many people, but it may well do, but it's important, believe me, very important. There's the book. Thank you very much to everybody concerned, especially to Sir Gavin and Gabriel Moss. I'm very, as I say, very grateful to everybody for their contributions. Do have a look at our review on the web and in the journals, and a very big thank you as usual to all concerned. Bye-bye.